Hi, I'm Patrick Nugent with IICLE. It's a tremendous pleasure for me today to be with Judge Warren D. Wolfson, who is a fantastic friend to IICLE. Judge Wolfson has been instrumental in the new laws of evidence that are going to be introduced, I believe, January 1st of 2011, right, if I'm correct. And together with the professional education group in Minneapolis, the judge and Tom Moway are going to be teaching a course December 3rd here in Chicago. We're going to be doing both a morning and an afternoon show that is going to deal with these new changes in the law. First of all, I'd like to welcome you, Judge, and thank you as always.
Happy to be here.
The judge brings over 34 years of experience on the bench. He was extensive academic experience. He's the intern dean. You're the dean now at the DePaul College of Law here in Chicago. He's also a fantastic author and lecturer, having written, of course, the trial evidence book, which he and Tom Moway have been teaching for over 9 years, I believe. And it's you're two of the most dynamic and fantastic teachers I've ever seen in trial evidence.
I won't argue with you on that.
I know I'd get no argument. Can you talk to us a little bit about how is this going to affect the lawyers in Illinois? Is there one or two things that you could tell us that will change for them or maybe will not?
Well, what the code tries to do is take the mystery out of evidence law. Before, if you wanted to know what the answer was to an evidentiary question, particularly in civil cases, you'd have to go to the library and find the right book and find the right case and then try to make sense out of the cases. Not always an easy thing to do. So we were lacking in predictability, which is important, and clarity, which of course is important. This code changes that. And now the entire law of evidence in Illinois cases concerning civil cases is in writing and easy to find, and all somebody has to do is read it. We did not change any statutes. All the evidentiary statutes enacted by the legislature are in full force and effect. We didn't repeal, we didn't modify, we didn't alter. So if you're trying criminal cases, then of course you're going to have to be aware of the statutes. But as far as civil cases are concerned, there is no more common law of evidence in Illinois. It's all in the code, and that's where you find it.
You know, Judge, you had the honor of sitting on the Special Supreme Court Committee for the Illinois Rules of Evidence and the changing of this. Can you talk to me just a little bit about what the makeup of that committee was, who was on it, how many people were on it, and what the dynamic of the faculty was?
Sure. Chief Justice Fitzgerald appointed the committee, and Judge Fitzgerald was the moving force and the inspiration behind this code. In some ways, it'll be his legacy. He appointed Don Hudson as chair of the committee. Don's an appellate court judge in the 2nd District. And he appointed me as vice chair. And at the time I was on the appellate court, and when I retired to take the dean's job, he said, "I want you to stay," which I did. Caused as much trouble as I could. But nobody gets everything he wants. At any rate, he carefully selected this committee, and it was represented every part of the legal profession in Illinois. Plaintiffs' lawyers, defense lawyers, both sides of criminal cases, judges, law professors, political people, people from the state legislature. Everybody was on that committee. And everybody was heard, everybody was considered. We were led in our sessions pretty much, well, Don Hudson was the leader, but we were pretty much led by our advisor, and that's Mike Graham, who's a well-known evidence professor. Cleary and Graham, Handbook of Illinois Evidence, is cited all over, and he's a renowned expert in the field. So he was our kind of spiritual guide through this. He too did not get everything he wanted. The quarrel became, do we adopt this federal rule or not adopt it, and a lot of them we didn't. Simply because Illinois law has always been different, and we didn't want any radical changes. If there was a clear Illinois Supreme Court decision on an issue, we followed it. We did not try to contradict it. So we wanted to have predictability in the evidence law, and I think that's terribly important. Lawyers should know before they go to court pretty much how evidentiary issues will play out. And that's what this code does.
That's great. In terms of the process, what was the timing in the process? How long did this take?
We met for about a year.
Okay.
We met in the appellate court building, and everybody came in from wherever they were. Attendance was very good. And then after we came up with a tentative code, we had 2 public hearings. One in Chicago and one in Springfield. We invited anybody who was interested to be there and be heard. And we invited anybody who was interested to make a written submission. So we had the benefit of what the bar out there felt. And there were a few areas where there was some controversy, such as the expert rules that I've told you about. There was controversy about whether prior inconsistent statements under oath at a proceeding of a non-party should be substantive evidence. They are in criminal cases. But, and I tried to get the rule in civil cases, I didn't get it. And it's not the law in Illinois now.
Right.
It's still impeachment, but it's not substantive.
Why should lawyers attend this course that are dealing with Illinois legal situations now?
Well, I'm going to try to tell lawyers, first of all, an overview of what the rules are about and how they're organized, so they know how to look for them. Because this is intended for quick reference, for the lawyer sitting at counsel table to open a page and get a number and find out what the rule of evidence is. And for the judge to do the same thing. And then I want to talk to them about what the code does not do and what the code does do. And we're going to go through specific rules. For example, we'll talk about the change that we made in how character is proved on direct examination. It used to be in Illinois, and we were the last of the states to do this, that it could be proved only by general reputation. We're changing that. Now opinion will be proper. But we didn't adopt the entire federal rule, which allowed cross-examination on specific instances of conduct. We didn't do that. There's a lot of debate about it, and we decided not to do it. So I want to go through all that so that the lawyers will have a working document they can go to court with and prepare their cases.